I did want. I don't know what that was. I did want to talk a little bit about, really quickly, just to give a little bit of context about the Election Protection Coalition and specifically the hotline. The 866 Harvote hotline is a year-round national nonpartisan hotline staffed by legal volunteers that can assist with a wide array of either questions or issues pertaining to voting. So, of course, we answer calls from anybody who has any question about voting, but our main mission is to be a support for folks who have who face historical or current barriers to voting. So, namely, voters of color, folks who are less likely to have certain forms of voter ID, especially in the world of DPOC, transgender voters, elderly folks, college students, literally anybody who needs voting help. And I work, again, in several states, mainly New Jersey, but I'm also in Tennessee right now, which I'm sure a lot of you have been seeing on the news is a hot spot for this redistricting following Callais. So I just wanted to talk about Tennessee for a second, shine some light on them, since they are a bit of a case study in just the immeasurable harm that this decision has had and the immediate effects that it's having on voters. So again, as many folks may already know, following the decision, Governor Bill Lee called. Yeah, sorry, I can put it a little closer. I didn't want to blow everyone's ears out. Thank you. I don't think there is. I can just hold it closer. Can folks hear me now? Okay, good. All right, so using Tennessee as a little bit of a case study, as many folks may already be aware, following Callais, Governor Bill Lee called a special session on May 5th, which is coincidentally the day of a special election there, so we were all very busy. And by May 7th, these new redistricting maps had already passed. So obviously a very rushed effort, no opportunity for public input. And what these maps did is they separated Memphis and Shelby County into 3 separate districts. So they cracked it, and this broke apart the state's only majority black district for the first time in 50 years. So that's obviously horrible on its own. But it's also coming to light that the state may not be requiring any official notification for voters whose districts have changed, which is obviously going to be super confusing for if voters who have voted at a certain polling location for however many years go there, and 1, they maybe can't vote there anymore, or 2, when they are able to vote, they may not be able to elect a candidate that represents them. So while there are thankfully multiple legal challenges already underway against this, and I want to do a special shout out to our community partners there, NAACP of Tennessee, Organized Tennessee, Civic Tennessee, who are out there every single day they were in session, not giving them a moment's peace while they were passing these awful maps. The reality is right now we don't know 100% what's going to happen. We can't fully predict these cases, and that doesn't, that's not specific to Tennessee. All across the country, we don't. Again, things are very uncertain right now. But what we do know is that this is causing a lot of confusion, it's causing a lot of disinformation, and it's causing a lot of fear for voters. So, one other thing I wanted to say was, all of this being said, I don't want folks to leave here totally disillusioned, because I do feel that they are counting on our apathy and our exhaustion to get away with this. So while I also want to validate that the feeling that voters, especially the voters who are facing, already baked in systemic barriers that are preventing them from casting their vote accessibly, and then we have the walls getting built even higher. While I want to validate that is very real to be frustrated, and folks may think, why use my very limited time and energy? Maybe I have a limited amount of PTO. Why should I use that to go and vote when politicians are purposely drawing maps to pick their voters and we're not picking them? And while that is a very fair, understandable thought, when I personally fall into that spiral, or when I talk to folks who are feeling disillusioned, I have to come back to a concept that I, again, frequently have to hold on very closely to, which is if your vote didn't matter, they would not be trying so hard to take it away. So in preparation for this panel, I took a look at some calls that have come into the 866 Harvote hotline lately about redistricting in the month following. And there were quite a few. We had a voter in Tennessee recently call to ask where they can access resources about redistricting. We've had a voter in Missouri call to ask, what does redistricting mean, and does this mean I won't have the option to vote for somebody in my party? We've had multiple voters in Texas calling to voice confusion about where their polling place is and if it's changed. And we've had a bunch of voters in Alabama calling saying, hey, I'm seeing what's going on in the news. I don't know where my polling place is. Am I registered? How do I update that if my district has changed? And do I need to update that? So while voters should not be having to think about these things, I'm glad at least if this is the moment we're in, they are paying attention, because this is going to require a lot of education. It's going to require a lot of attention, and we're going to have to keep our eyes on it. So, of course, in our organizational capacities or as voting rights advocates, this will mean increased education. But on an individual level, it can mean talking to folks about, hey, what's your plan to vote? Even if you think your registration's up to date, let's just check it together. Or it could be offering someone a ride to the polls. Anything that we can do to mitigate some of these logistical barriers in getting to the ballot box is going to help while we're on the same front battling these more structural and legal barriers. So I will stop talking now and pass it over to DaWuan, but just want to one more time express my gratitude to be here with you all tonight and to learn from you, and I'll pass it over.
Alrighty, so I will keep this very quick, but I have given talks on the Callais decision quite a lot since the decision came down from the court. But I think it's important to kind of ground the conversation and like just have a bit of background and framing about what we're talking about here, and it's the exercise of Black political power in particular. And so when addressing the 1974 Puerto Rico Solidarity Rally, Ella Baker declared, "I am here to represent the struggle that has gone on for 300 or more years, a struggle to be recognized as citizens in a country in which we were born." This is an important framing because this Supreme Court is one that is deeply interested in what I refer to as the project of perfecting slavery. I frequently refer to this court as a Dred Scott court. Dred Scott being the case in which the court held that Black people were and could not be citizens of the United States. The Dred Scott ruling was overturned by Congress through the ratification of the 14th Amendment. The 14th Amendment was the second in a trio of amendments that we refer to as the Reconstruction Amendments. And while it was the 14th that secured citizenship for Black folks after the abolition of slavery, it was the 15th, securing the right to vote for freed Black men, that led Frederick Douglass to remark that for the last 30 years I have often appeared before the people as a slave, sometimes a fugitive slave, but always in behalf of the slave. But today I am permitted to appear before them as an American citizen. How great the change. And so following the ratification of the Reconstruction Amendments, we began to see the first Black lawmakers elected to the U.S. Congress. And during this period, Black representation in the federal government grew to 14 members of the House and 2 U.S. senators, all representing the South. What followed was rampant voter suppression efforts and Jim Crow laws to quell the Black representation and political power. And as a result, the last Reconstruction-era Black representative, George Henry White of North Carolina, left Congress in 1901. The 15th Amendment would lay dormant for nearly a century until the passage of the Voting Rights Act of 1965. And following Congressman White's departure in 1901, there would be no Black legislators elected from the South until 1969. 4 years after the passage of the Voting Rights Act. And with that, I'm happy to get into questions and conversation. Are we sitting back? Are we standing for the entire?
No.
Okay.
Just so they can see your face.
Okay.
I don't know if I could just start it off. I am not an attorney, and it is a little confusing how they have, over the years, appealed, and decimated every section. So section 1, 2A, 2B. I was wondering if you could sort of, I'm sure you all know, but maybe I don't, and it's a little selfish. Start from that point on how they've eradicated it from, there's no more discrimination in the South, so we can get rid of this part. And now we're going to take the majority-minority areas and fracture them to, now we're going to state houses and infiltrating those. If you could just speak on from the federal to the state level, and also maybe touch on New Jersey, and then finally the John Lewis Voting Rights Act. Sorry, I was
Yeah, that's an easy tax. Thank you. So in terms of the project to dismantle, disintegrate the Voting Rights Act, the case that we often turn to is Shelby v. Holder, in which the court got rid of Section 5, made Section 5 of the Voting Rights Act unenforceable, basically, which was our pre-clearance mechanism. And so both Section 5 and Section 2 operate as a shield and a sword. That is how we often refer to them. Section 5 was the shield because it required pre-clearance. And so if any jurisdiction that had had a history of racial discrimination, if they wanted to make a change to their voting laws or voting rules, they would have to get it approved by the federal government first. And so that was the shield. The sword was Section 2, and it feels so weird to say was Section 2. And so Section 2 provided the mechanism for bringing lawsuits to allow for political power, the practice of political power, particularly for Black voters to elect the candidate of their choice. And so, like I said, this project starts far before, but Shelby was like the real turning point. That this was a court that was okay and comfortable with getting rid of what many call the crown jewel of our civil rights legislation. And this is, of course, it comes in direct response to a Black man being elected president of the United States. That too is too much of an affront to the American project and what it is supposed to be. And so we see this reaction. There was this myth that we were now living in a post-racial society, that these were things that were not necessary anymore. And the proof was Barack Obama was in the White House. So surely, we've solved voting. Voting is fine. And so, again, when I talk about the background and the framing, I view my career, my work, as a response to the Supreme Court's project of perfecting slavery. And I refer to, I say I am interested in the project of perfecting citizenship. Citizenship meaning belonging to a government that is accountable to you. And so that really is the lines on which this thing falls. It really is just about slavery and citizenship. And everything that comes with citizenship, the ability to, elect the candidate of your choice, to have your voice heard. And so this is a court that has committed itself to that project. And it was a very quick departure because I worked on a case called Allen v. Milligan that was brought before the Supreme Court in 2023. And that was a case that challenged Alabama's congressional maps. And so we argued under Section 2 that the Alabama map could be redrawn so that there would be two majority-minority districts allowing Black folks in Alabama to cast the vote for their candidate of choice and elect their candidate of choice. At the time, Alabama, the one Black district in Alabama was along the Black Belt and then had like these tentacles that reached in and like grabbed Black folks from Montgomery and from Birmingham. And so it just stretched out to like grab those two cities where Black folks are and ensure that, there would be, it would be impossible for, any other district to elect a Black representative. And so we were nervous then that, we know where the Supreme Court is headed. We know that they have their eyes on the Voting Rights Act. And so is this going to be the case in which they've, overturned Section 2 or like they decide, to do what they did in Callais. And so what makes it so interesting is this was just in 2023. And so this is a fairly quick departure from the court to change its standing on a particular piece of legislation or topic. Oh, New Jersey.
New Jersey.
Well, As we have seen these attacks on the Federal Voting Rights Act, there has of course been a push to pass state voting rights acts that can stand in the place of the protections that were lost, that have been lost under the Voting Rights Act. And New Jersey is no different, and so we are actively working to get the John R. Lewis Voter Engagement Act, VEA. It's our state VRA, but it's the VEA by title. And so that is a current effort that has been ongoing for about 3 or 4 years now. But I think in light of the Callais decision, there is an urgency that this moment creates in terms of protecting the right to vote, particularly for people of color. And so, we would urge you to give Mikey Sherrill a call.
I have the SAVE Act and
Wonderful.
and the John Lewis Act.
Yeah.
QR code. Everybody can do that before
Wonderful.
they meet. So
Yes. That is an action that you can take and get involved and let Governor Sherrill know that New Jersey needs a strong state voting rights act.
What are the top 3 items in the state voting rights act that they worked on in the state?
Yeah, so with the state VRA, it includes a pre-clearance that was what Section 5 of the Voting Rights Act did. It would include a pre-clearance that would require jurisdictions to get approval by the state government before they can make any changes to voting that could have a potential racial impact on voters. And so that's one of the key provisions, and it's also it also includes provisions around supporting voting, making sure that folks have access to the ballot, that there are remedies that are put in place if something were to happen, and so that's kind of like the gist of it. But yeah, that's the VEA.
Should we open it up to questions from the audience?
Should I bring the mic up? Or do you want to stand up and? Great.
I was asked by a few friends to ask you, and I think everybody here would be interested to hear the answer. A few different things that we can do, not being lawyers. As what can we do to support this work?
Yeah, I think I know y'all have the action cards. I definitely recommend. Yeah, I definitely recommend scanning those, going to those websites, sending those action forms, those requests, letting the governor and our legislators know that you support a state voting rights act and would like to see a state voting rights act passed in New Jersey. I think your presence here tonight is also incredibly important. To remain interested, to learn, and then go out and educate others. I always tell folks one of the best practices we can do in these times is to get to know your neighbor and take care of folks and be in community with folks and show up and support. And one of the ways we do that is making sure that our friends are informed. And so those are some actions that I always recommend. And I know Lawyers Committee has a whole plethora and list of things you can do.
I just want to echo a lot of that. But like you said, the education piece is going to be really, really crucial. And also, again, the state VRAs are also going to be just immensely important in kind of safeguarding some of the very limited protections we have left. But in terms of education specifically, one of the things that we're doing, adjusting our messaging, is being a big thing. First of all, inoculation messaging for some of the misinformation that's coming out there following redistricting. This is obviously a really politically charged time, and a lot of people are really scared right now. And so one of the things that has been coming up is like fear, like I don't want to get arrested for voter fraud because I'm confused about what district I am and I'm just trying to go vote. So pushing that inoculation messaging out there, but also encouraging folks to vote early. Voting early is going to be immensely important because if let's just say your polling place changes and if you go you're there first day of early voting 2 weeks out and you say, oh, like something's wrong, I need to change something, you have a little bit of time to do that, and those deadlines are less likely to have passed. But if you go on election day 30 minutes before the polls close, and you are at the wrong polling place, and again, you didn't get any notice, which is not your fault. Your options are going to be a lot more limited. So one, voting early, and then voting by mail, especially in New Jersey, where voting by mail is a little bit more accessible for folks. Your district doesn't really matter as much if you're just mailing your ballot back. So of course, mail early. The early is all I'm going to say tonight. But doing those things to kind of offset some of the barriers that are intentionally being put up to block you from voting on time, or just your participation in democracy. So that's the main thing I have.
In Tennessee specifically, or the other states where we're seeing these attacks, what does the ACLU have in plan in November in terms of getting people out to vote? Of course, early would be great, but also in November, the before. What's here? What do you have in plan? Please repeat the question.
Okay, so the question was, what is the plan? What is the ACLU's plan to help people vote in states that have redistricted in response in the aftermath of Callais? Was that in states like Tennessee? And so, I again, the biggest thing is just engagement and education. It's here in New Jersey, we have expanded our policy team to include a civic engagement arm. And so we've got an organizer and an associate director of civic engagement who do really wonderful work to connect with our membership, grow our membership, and then also make sure that folks are informed. So that includes get out the vote days, texting, text banking, phone banking, all of those different ways to kind of connect with voters. That also means, we attend events all the time. And so really just focusing on engaging and educating, and I know the ACLU affiliates in those states are doing their best and to get quick messaging together, strong messaging together to ensure that folks have an awareness and know what to do when November comes along. And again, these things are rapidly changing, and so we're also kind of just preparing. We see what the intention of these states are. We know what the goal is. We know what the plan is, and so building up a defense as much as possible and as early as possible has been one of the key goals.
You remind people about donating, about the importance of litigation. And donating to
absolutely.
organizations like yours.
Right. Yeah, we always appreciate the support.
No, it's critical.
Yeah, the support is critical. Hey, it's all one big ACLU family. If you're concerned about what's going on in those states and you want to donate to one of those state affiliates, I also encourage that. Also, send a few dollars New Jersey's way if you like. I think. And then, of course, when it comes to litigation, that will happen in the aftermath. There are things that we see that are challengeable. Those things would follow an election. There's nothing we can do beforehand. But if there are acts on election day or whatever, we will be able to then litigate and challenge those methods as well.
This gentleman over here.
Just to repeat districting. I was a councilman here over 30 years ago. Bill Pasquale was the congressman. And if we remember, if we're older, there was a guy named Rothman and Pasquale. We went from 13 congressional districts to 12. And there was a fight. Pasquale won. I'm concerned with the aspects of what Abbott did. I'll get 5 seats, and what Gavin Newsom, he's going to get 5 seats, and we'll get one here in Indiana. You get the picture. I'm more concerned about something else that isn't, to me, mentioned enough. What if you take and put 3, I'll say, Democratic congressmen into the same redistricted district? Get it? There's going to be a fight and a bloodbath, and it's going to be a triangular firing squad. So it's not just who votes which way, left, right, whatever. I'm concerned about that as an ulterior motive that will be starting to occur. Trying to put, let's say, take Houston with 5 million people. You start bunching people together to spread it out. So that's it. The other thing is, I get a call every other day from the DCH, which is the Democratic Legislative Redistricting Committee, who never leaves a message. I answer the phone, I say, okay, I'm almost done. I say, you know what? I live in a District 11 where 11 people ran in a primary on February 5th for Mikey Sherrill's seat. That's fine, it's democracy. How our laws let 34% win, that's what Mikey got when you think about it. But that's us. The point being, there was no message on what district you're in or how it's happening from our Democratic chairman. Nothing from Ken Martin, nothing from Leroy Jones. I'm not saying who you're for, I'm saying people all over Facebook are saying, what is this third election? What's going on here on June 2nd? We voted in February, we voted in April. They don't know. Now that's not up to the candidates. That's up to leadership. And as a proud wife and I, 30-some year member ACLU, please, that's the thing. Beat the hell out of the Democratic bosses and say, chip in. I'm worried about bundling candidates.
Is it more
together.
messaging you're worried about?
Messaging and bundling.
And just getting the word out? I don't know, do you
Yeah, well, one, thank you for being members of the ACLU and for so long. Yeah, I think, and that is definitely, the amount of elections that have happened recently. That is something that our civic engagement team has really been active on, is informing voters, connecting with voters, staffing those elections, just being, just engaging with folks as much as possible and educating. I think I'm just going to keep saying that tonight, but that really is what's at the core of it. Of course, we're nonpartisan, but we agree that messaging is key, and so that is, a big goal of our civic engagement department, is to be ensuring that there is an understanding and awareness, and that folks feel well informed going into the polls.
In terms of going to court on this.
No, all good, all good. I'm like, why can't I here today?
No, it's the air conditioning.
Okay.
Yeah.
Right, my question is, how effective the courts are going to be or has been in terms of responding to to action, or just responding to cases that are brought to them on a specific day to get back a response that can be that will be reacted to by the body politics. In terms of just something happened in a particular district, go to court. How quick can we anticipate that we will get a response from a judge or whomever is hearing the case that will impact the election in the moment? As opposed to some weeks later, as opposed to some weeks later when the election is over.
Mm-hmm. Yeah.
I'd also add on to that about the shadow document. Can you even speak to that?
Oh,
I'm
yeah.
sorry. Because a lot of things are being decided quickly and under the covers.
Yeah. So there are several layers of answer here. The first two challenges, getting a response from the court when we're talking about an instance that's happening on election day and will impact an election. We are able to file emergency petitions to the court and get very fast responses and orders from the judges, and because these are things that are anticipated on election day, and so we have those mechanisms in place. I know that's a lot of what 866 Our Vote is doing, is getting information about these. You talk about 866 Our Vote. I'm like.
Yeah, I can't speak to the court side as much, even though I do work with mostly lawyers and they're all amazing. But 866 Our Vote is a really good way for that information to get funneled up to the lawyers. So when I think of emergency litigation, for instance, for November, we're obviously preparing for things like because of the polls, those kinds of things. But even for more quote unquote admin issues, if a voting place doesn't have Wi-Fi for 3 hours and people can't vote, that requires, or they don't have power, that requires the hours to be extended, because again, multiple, how many people lost the access to vote during that time, and they might not be able to come back by 8 p.m. or whenever the polls close. So filing that emergency litigation is key, of course, but getting that information of someone reporting it is also a big thing, because if we don't have that information, then we can't file the litigation. And if we have witnesses who are there saying, hey, I was like waiting for an hour to vote and I couldn't, and this is disenfranchised me, like what can we do? And having someone there where you are able to again file that litigation, and again, can't speak to the litigation part as much, but it is still important to funnel that information upwards and just have a place for it, and also to have a place where voters can call to express frustration, call to express concern about these things, because it is also scary if you're waiting to vote and you don't know if you'll be able to. So having a place to just talk to a legal volunteer, a voting rights expert who can kind of guide you through what to do, what your options are, but then also again have an avenue for that litigation.
And in terms of that litigation, a voting rights case can have quite the lifespan. So not one that happens on election day, but one, say a case brought under the Voting Rights Act, Section 2, when it was in place, we can still bring the challenge, but the efficacy of Section 2 has been diminished. A voting rights case can have a long lifespan depending on the subject matter, and if it is something of interest to the Supreme Court in particular, they will weigh in via the shadow docket. And so the shadow docket is the court can issue decisions, can issue orders in cases without having heard any oral arguments, And it is the shadow docket because it's just the justices, and we don't know when it's going to happen. We haven't heard the arguments. We don't know. Typically, like oral arguments allows for the public to also hear the arguments that are being made, but also the questions that the justices are asking. Like, what are the things they are considering? And many of these opinions from the shadow docket come with no explanation at all as to why they have ruled in the way that they have. I became quite familiar with the shadow docket during the Allen v. Milligan litigation in Alabama. The district court had ruled in our favor, and this was in 2021. We got the order from the district court ruling in our favor. We celebrated that win for about 4 days before we got notice from the Supreme Court via the shadow docket that they were going to put a stay on that decision, meaning that it could they could not redraw the maps. The court decided to overturn the district court decision. No arguments have been heard, and we just got the order. And so what would have been a win that allowed for a map that included two majority-minority districts to be in place for the 2022 election, the Supreme Court stepping in via the shadow docket their ruling made sure that the maps that had already been in place with the one district would remain the map for the 2022 elections. They would then hear oral arguments for the case, and I want to say that was October of 2022, and then release their decision in June of 2023. And so what could have been 2 election cycles with these maps was then shortened to just the one. We had to wait until 2024 for those maps to actually be utilized in an election and determine what the congressional districts of Alabama were going to be.
Do you want them?
Okay, thank you. So there are 2 things. One is Roberts and his belief not so much in a post-racial but a post-legal racism.
Yeah.
All right, that legal racism no longer exists, but he doesn't talk about customs and systemic racism. So that's a real problem in terms of how he makes decisions. And then the second thing is that this is not just about federal elections or statewide elections, but it can also have an impact on local elections, on school boards, on who becomes mayor. I mean, in Montgomery and Birmingham right now, you have two outstanding black mayors.
Yeah.
Well, how long is that going to last if the redistricting comes
Yeah.
in? So it's not just about federal and state election, but also local elections.
Yeah, absolutely, and thank you for highlighting the local election aspect of it. So my very first case out of law school was a Section 2 challenge in Galveston, Texas, to challenge the racial gerrymandering of the Galveston County Commissioners Court. There had been an effort, nearly a 30-year effort, to try to get rid of the black seat in Galveston County. And so I say that to highlight the importance of what Section 2 means on the local level, because that we're talking about the direct representation on the county commission, and the ability of black folks in Galveston to elect the candidate of their choice. Another example is my own hometown of Fort Pierce, Florida, that I hold very dearly. We elect, our county commission is broken up into 5 districts, but and a representative for each district, but we use at-large election methods. And so that means that despite being drawn into districts, the entire county can vote for each commissioner, which effectively rules out the say of black voters in my hometown. So for our county, my hometown is a majority black city, while our sister city in the county is one of the fastest growing cities in Florida and is incredibly white, which means that because we use these at-large elections, despite the fact that District 5 is the district that is drawn for the black neighborhoods in my hometown, the white folks in Port St. Lucie get to decide who's going to be on the county commission. And so that was another thing that Section 2 allowed us to challenge. Section 2 allowed us to challenge at-large election methods that dilute the political power of black voters. And in fact, our city commission was actually, through court order, changed from being at-large elections to district elections. And it was only then, in 1993, that that black voters in a largely black city were able to elect candidates to their city commission. And so that's what, at-large elections, that's the impact that at-large elections can have. And then unfortunately, in the aftermath of the Callais decision, there has been a new group that has come up that is arguing that the 1993 court order should be, that we should get rid of that and we should redraw, that we should change the elections back to at-large, which would then make it virtually impossible for black voters in my hometown to elect the candidate of their choice on the city commission. So I thank you for bringing me back to that, because I mean, of course the congressional races are important, and the redistricting that we're seeing is alarming when it comes to at the federal level. But yeah, this will have impacts at every level, and so I really can't be overstated what the Supreme Court has done with the Callais decision. Oh.
This gentleman has been waiting all night to get and then Donna.
We've been talking about reaction to the decision, and we've been talking about messaging and how are we communicating with the voters who are in affected districts, and you're talking about lawsuits. So we're sort of talking about curing the symptoms of this disease. How do we, or addressing the symptoms, how do we cure the disease? What do we do going forward, nationally, period?
Really?
Yeah.
Because I really wish I had a good answer for you, and I'm afraid I don't. A lot of these things I feel like are held up in the legal sphere, and DaWuan, after I get through my piece, I would also be interested to hear, like, from a legal perspective, once something comes down from the Supreme Court, like, what really can be done. It's my understanding that's kind of the end all be all, but then when the court is incredibly hostile to black voters, to voting rights in general, like, we can't just kind of let that happen, and then we are kind of stuck figuring it out. So I don't know. I really hate to say I don't know, but that's a really tricky question, and I think a lot of it is going to come back to, as much as we can, doing state VRAs, doing the things we can on a legal aspect where we have maybe those good relationships with our, you know, our local election officials, if, you know, in a nonpartisan like capacity. For example, I think of election protection folks have a lot of good relationships with election administrators, election clerks, talking to them about, you know, again, if while in the meantime we're figuring out how to cure the disease, as you said, like, what burden can we take off them in terms of, like, you know, how can we best notify people, what can we do in the meantime? So that's a fantastic question with a tricky answer.
Yeah. Thank you for braving that. I apologize for putting you on the spot like that. I needed some time to figure out how I was going to answer this question with my ACLU Policy Counsel hat on, because I really want to answer it as DaWuan, and so maybe afterwards we can have that chat. But yeah, I mean, this is the danger of, again, a Dred Scott court, this Roberts court.
Can I say something? What do you think?
Yeah.
I think that most of us in here who are, I'm not good with this. I don't like. Is this right? Okay. I just think that people of my color, we have to have that conversation with our family, our friends, and let everyone know what it's all about, what the racism that we see and that we want to defend. I think that what country we want, we have to be brave enough to have these conversations. So it's great.
I'm very intentional about calling the Roberts Court a Dred Scott court. One, because I think it really does emphasize the level of harm that they are committed to. Not just, you know, oh, well, we're bound by the, no, this is a decision, this is an agenda, like, this could go very differently. But I also think that it is resonant because it is a reminder that the more things change, the more they stay the same. James Baldwin said in Notes from the House of Bondage that the goal isn't to turn back the clock. The goal is to make time stand still. And I think that is what we see from this court. Because if time stands still, it doesn't have to be accountable to anyone. We don't actually need to see change. We don't have to. And I think this is a court that, when we're talking about the disease that we're looking to cure, it is one that has been growing and has infected itself into everything. And so that is the battle that we're up against. And yeah, once the Supreme Court says something, that is the law. That is the law of the land that we must follow. And of course, we can still fight and challenge, but at the end of the day, 9 unelected individuals get to decide not only who can vote and who can't vote, or they get to decide who lives and dies. Yeah.
Yeah, I'm also interested in your thoughts on the latest stuff that's happening. You know, it looks like this bipartisan housing bill is now being held hostage
because of a bipartisan, like the first piece of bipartisan legislation we've seen in a long time, as being held hostage. He just turned it down because he wants to cram in this voting states, the SAVE Act, which is going to affect. Can you talk about the implications of that if that's successful, and what that's going to do to states like New Jersey that have liberal vote, like mail-in ballots, early voting, votes are counted after election day, etc.
I think that speaks directly to the last point I made of, they get to decide who lives and dies. Because we're talking about a housing bill. We're talking a housing bill that is being held hostage in an effort to further gain control of our federal elections and disenfranchise so many people. I mean, the SAVE Act would require, documents that many people do not have. I've lived in Florida, I went to school in DC, I moved to New York for law school, now I'm in New Jersey. And I can't tell you where my birth certificate is and all of that. And if this were to happen, I would run the risk of not being able to register to vote, to be able to vote, for no other reason than the fact that I moved for my education and career. Individuals whose names change, just across the board, it would be incredibly harder to register, keep folks informed. The goal is to spew as much confusion as possible, and that's exactly what the goal is, and that's exactly what they're after.
I feel very similarly. It's also very frustrating how, if, let's just say, again, can't pass the SAVE Act on its own, we're going to hold up something else to do that. Or, let's just say I'm not getting the way I want, for voting. Okay, I'm just going to do an executive order, and you guys just have to follow it. And that's also, and then we do. And I'm thinking of the USPS rule that's coming out. So it's tricky because it's on one hand, we obviously cannot just sit by and let this happen, but then when it seems like people are complying in advance, that is also a terrifying thought, because again, that's just, we're on the slipperiest of slopes. Yeah. So I think it's going to be, again, challenging the things that when you're, all of this is unlawful, but when you're doing this unlawfully, when you're just writing random things and expecting organizations to comply, it's going to be doing everything we can. I'm thinking of the comments are due soon for this USPS mess that's happening on, but I don't know. It's tricky, and the SAVE Act also, again, is terrifying for a lot of reasons. I think, again, I have someone who's changed my name before. I'm also moved states several times, and I also think about women or people who have changed their names after marriage. It seems very intentionally targeting for them. So I don't know. This is something, again, we can't let any of this pass, but that's something especially. So
yeah. Just to kind of level set about where we are, the state of things, and how I feel as a lawyer. As you were talking, you mentioned, Donald Trump signing an executive order to enforce the SAVE Act. My immediate thought was, well, that would be an easier legal challenge because the Constitution says that that elections rest with the Congress and the president cannot. And then I was like, but wait, that doesn't matter anymore. The Constitution doesn't matter anymore. I'll never forget, one of the days that changed everything for me. I was sitting in my state and local government class actually during law school, and I don't even remember what the question is, but my professor just goes, LOL, nothing matters. And I've stayed with that because it really, they are running no jurisprudence, just vibes, and intent to do the most possible harm, most harm possible. Yeah.
So Has there been any discussion when it comes to Callais to talk about what would the hurdle be that we would have to achieve in order to get rid of the voters' rights as a way for us to define when that would happen? I mean, when I saw the quote from Alito, well, you know, minority folks and white folks vote at the same rate. That's the parameter he's going to use instead of like, shouldn't we be defining that? And clearly what's happened since then has completely shown that there is a lot of racism out there.
Yeah.
So has there been any discussion in this corner? What would that be?
That's all we've been talking about. That brings an important point about what the court did in Callais. The court could have said that Section 2 is unconstitutional, as they did in Shelby v. Holder with Section 5. They could have said that. Instead, they decided to rework the framework, the legal analysis. It's called the Jingles preconditions, the test that we use to see, whether or not minority voters, if voting, if in a single district would, if the voting power of minority voters is substantially large enough that they would be able to elect the candidate of their choice, if not for the districting map or the at-large elections. That felt such a lawyerly sentence. And so when in doing that, the court famously said that partisan gerrymandering was a political question that is non-justiciable, so the court wasn't going to weigh in on it. And now we're saying that no, wait, it's not race, it's party. And like, black people could elect the candidate of their choice as long as it's the same candidate that the white folks want. Like, that is literally the argument that Alito made. And so when you take something like the Voting Rights Act and you pull it completely out of its context, this is basically the exercise that Justice Alito undertook, was just to remove all of the context. And so yes, we did the test called for, whether or not there was a history of racism, history of racial discrimination. And there were so many ways to show and to prove it. And now those have, been stripped away. And so they could have said it was unconstitutional, but instead they just eviscerated it and made it inapplicable. Like, it just, you can't, it's in effect, like, it doesn't work anymore. It would be impossible to make these arguments because they would just say, well, wait, no, they're just doing, this has racism involved here at all. Like, this is just about party.
Right.
Yeah. Yeah.
And am I allowed to ask a question?
Yeah.
I would also be curious to see, like, and first of all, I personally don't understand how partisan gerrymandering is allowed in the first place, because that also feels extremely weird. But I guess, one thing I would think of, and I was on a call today about this decision, and we were talking with multiple state partners, and I think of our friends in Florida where, partisan gerrymandering isn't allowed, and, so that when these new maps that Ron DeSantis just signed, they can't hide behind that and say, oh, it's, it's for partisan, okay, well, you can't do that either. So, like, what would the pathways be to maybe eventually, like, getting rid of some of this partisan gerrymandering that has the same impacts?
Yeah.
Thank you for letting me ask the
Yeah,
question.
no, of course. So yeah, the thing is, racism, of course, hasn't gone anywhere. They've just gotten a little bit more sophisticated with it. We can't, huh?
Now it's in the Supreme Court.
Right.
That wasn't there before.
Right. Like, we've seen this before. Robert's gonna have to give an account after all of this is said and done. But what was the question again? I'm sorry. The pathways
to, like, getting rid of
partisan gerrymandering. Yeah. So I mentioned that the Supreme Court had decided that partisan gerrymandering was a non-justiciable political question that the court cannot weigh in on. Of course, that then opened the door for the political parties, one in particular, to say, hey, all the folks of one race vote one way, for one party, and most of the folks in the other vote for the other party. And the Supreme Court just said they won't be weighing in on partisan gerrymandering, so we don't even have to break it down to black and white. We can just break it down to blue and red. And so the use of party as a proxy for race. And the argument that we made, that I wasn't there, the argument that was made in Rucho v. Common Cause is the name of the case, was that partisan gerrymandering should be unconstitutional because it uses party as a proxy for race. The Supreme Court said, sure, but we can't touch it. The Constitution won't let us touch it. This is a purely partisan, we can't touch it. Meanwhile, you can rule a certain way in Callais, and then the moment that all the other Louisiana, Alabama, and Tennessee all said, hey, Supreme Court, is it cool if we go ahead and do this? And they're like, yeah, fully. And it is interesting that all those states got the go-ahead from the Supreme Court, but Virginia, after Virginians voted to redistrict, voted for it, the Supreme Court refused to take any action. Interesting enough. And so I think, and one of the real things that we need to do is demystify like this idea that the Supreme Court is not a political body. They are political agents. They are very political. And every decision that they make is political. Let us be very clear about that. John Roberts was the man that said that the Supreme Court's job is to call balls and strikes. The Supreme Court is doing the pitching. So.
Did you have a question that you heard?
I have a question. There has been this discussion about increasing the number of justices on the Supreme Court. And I'm just wondering, how would that play into this particular situation?
Worse.
I mean, one way or the other, I mean, what one party versus the other. So that's my question. What's your...
Well, I'd imagine that we'd have to wait until the next president.
Hell yeah. Okay. Got this ACLU hat on right now. I'm taking it off. I'm taking it off. Right now, y'all are just talking to DaWuan Norwood. I don't think any serious Democrat that wants the presidential nomination in 2028, in my mind, must commit themselves to expanding the Supreme Court. It is the only answer that we have right now. Because again, this is a body of 9 unelected individuals who serve life terms. And they are accountable to no one. There was President Biden put together a Supreme Court commission to do a review of what can be done to reform the court. It's a very long report that the commission released, and of course the shortest portion is the portion on packing the court. But packing the court is the most legal remedy that we have, the most constitutional remedy that we have to addressing the Supreme Court is court packing. And there's precedent for it. When Antonin Scalia dies, what was it, in February, March of 2016? Early. And Republicans, and the Senate says, no, we're not gonna hear your nominee to the court to replace his seat because it's an election year. It's too close to an election. The next president should decide. That's court packing. When just a few years later, Ruth Bader Ginsburg dies During an election season, millions of votes had already been casted for the next president. And here Amy Coney Barrett is, sitting in a confirmation hearing, days out from the presidential election. That's court packing. And so, if we are going to be serious about opposition to what we are seeing, we are going to have to change the playbook. And I think expanding the Supreme Court. And y'all mind if I pull out my phone real quick? Because I was literally just texting a friend about this. And let me see if I can, what can I do to search it very quickly? Oh God, maybe if I just type in 13, because I think 13 is the number I want. Yeah. Okay, Supreme Court. So many messages are about to come up. Lord, how can I? Maybe if I expand, let's see what happens. Ooh, right. If we were to have one justice per circuit, as was the case when there were 9 circuits, we had 9 justices, a justice was assigned to every circuit. We have expanded from 9 circuits to 13, which means it would only make good sense to have 13 justices, 4 more seats to the court, which that alone, just those 13 would secure us a 7-6 majority. That's all we need.
As long as Trump doesn't do it before we
Right. And then potentially, because some of our justices are up there in age, potentially by the end of the next president's term, we could have a 9-4 majority on the court. And that is through the simple act of the number of justices should match the number of circuits, 1 justice per circuit. Don't sound like the most absurd thing to me. Nothing?
I have nothing to 10 out of 10.
Can I ask you something? President Trump has now taken away the money that was going to go to state elections. And what are we going to do? What is the country going to do? What are the states going to do? You know, without that money, we can't run a state election, a secure state election.
Yeah, absolutely. And I think that speaks directly to the fact that they are approaching this from so many angles. By hook or by crook, they're going to make sure that voter suppression is carried out in some way. It seems as though the tools in their toolbox are limitless. They are becoming ever creative with the ways in which they could, destabilize the election process. Of course, refusing to send that money is going to do that.
Exactly.
And so yeah, I say our opposition, we can't take them lightly. Like, don't get me wrong, they are dumb. Like they are stupid, but they're also organized. They're organized and they're crafty and they are so creative. And I think this moment requires that we be just as organized and just as creative. Because this is not a project that, starts in 2020 in 2016. The groundwork had been laid. I think the moment that the Supreme Court selects a president is the moment we should immediately question whether or not this is a body that should exist in this way. So.
I also think this is a good opportunity too to, what we can do again, if they are going to withhold money and try to make things as chaotic as possible, what we can do, on an individual scale and on a scale that costs no money to do our part to try and make things run as smoothly as we can, despite all the obstacles being thrown our way. I think of one of the big arms of election protection is poll monitoring. So, if you have the time and if your heart calls it, poll monitor, that is a great way to, you're out there able to assist voters and, if they have issues or if, let's just say, God forbid, there's since they withheld money, the machines are breaking down. How to escalate up the chain to subject matter experts. I think of our wonderful partners at Verified Voting. They have an e-weeks program, which is all they're solely dedicated to solving machine issues, and they're stationed outside polling stations to say, okay, this is what you need to do if machines are breaking down, if the Wi-Fi isn't working. And sometimes again, poll monitors or our poll workers who are in there, they're very well trained, but sometimes technology is really difficult sometimes, and it's good to have again experts there, subject matter leaders there, and state leaders there who can be stationed outside and provide that additional support to voters, letting them know what their options are when it's coming down from the very top that they want to make things as chaotic as possible. So just a shameless plug to sign up to be a poll monitor if you would like to.
No, volunteering on election day is so fun.
It is.
Like, it's so fun. Everyone should do it if you can. Election days for me growing up were like a holiday. My grandmother worked at our supervisor of elections office in my home county, and so election days were like the days I got to go hang out with grandma, and I just would be able to just watch people vote and see the excitement about the ability to do so, the joy that came with it, especially with the black folks in my hometown. It was also one of the few nights I got to stay up late. I was like, ooh, we're watching the election results come in. And I miss when I felt that excitement about elections, and I feel it again every time I get an opportunity to work an election, to volunteer, to do this work. And so it's also a good point of joy. And so if I think we all need a lot of that these days, and so remaining joyful is also, I'm trying to end on a nice note. Yeah, remaining joyful is also, they hate it. They don't want to see us happy. They don't want to see us, they want to see us in chaos. They want to see us, again, they want to decide who gets to live and who gets to die. And so I tell folks all the time, the goal of slavery is to kill you. And so if I say that this is a project of perfecting slavery, okay. Are we?
We're at 8:15.
Okay. Oh my.
I don't know if you want to stay a little longer and speak afterwards, or.
Yeah. I just have a quick question along those lines. What's going to happen when they send in the National Guard to the polls on election day? And security, all of a sudden, ICE people show up. I'm in a car with you. What's your right? No. I'm talking about election day. I know.
Do you want to take that one? Yeah, and then we'll wrap it up.
Yeah, I can answer super quick. This was as folks may know, DC's primary was on the 16th, and again, as folks may also know, DC is absolutely swimming in National Guard right now. We historically have not had a DC election protection program, but this year, in this new landscape, we thought it would be absolutely crazy not to. So myself and my colleagues, Nick Gothard, and a few others got together and banded up a new program to kind of combat this, because we were seeing a lot of National Guard kind of parked outside drop boxes, which even if that's where they're usually stationed and it's not intentional intimidation, it's still intimidating. It's still having that chilling effect. So they were able to talk directly with the Board of Elections and get orders sent out to say that you have to stay 50 feet away from a drop box. And even though on election day itself we did see them violating that order several times, we had the physical paper from their orders from the top to say you can't do this, and we're in communication with the Board of Elections. That is a special case because it's not every state where the Board of Elections or again the election authorities are friendly or am going to pick up the phone when voting rights advocates call. But that was a good case study to see it is possible to get some kind of limitations on, so they can't just free for all intimidate everybody. So that was a big victory for us. Again, even though things were still a little chaotic on election day, having something to say you can't do that rather than nothing and just trying on an individual level to talk to them, it was helpful. So we'll see how it goes in November. Of course, that's going to be a much larger scale, but we did find some success there in combating that.
Yeah. It's definitely something that's front of mind, that is being considered. I know a lot of groups are working on resources to inform folks of what to do if there were to be federal troops at polling places. the easy answer I always want to say is troops at polls is illegal.
Yeah.
But illegal doesn't matter these days. And so, knowing this reality.
Open carry is the law in a number of states. So could easily have guns that are not associated with the National Guard.
Yeah, that is true, and a lot of, you know, we also have mechanisms in place for all forms of voter intimidation, and troops at the poll is exactly that. It would be voter intimidation, and so we do have, you know, methods of remedy for that, and that is also another key provision of the State Voting Rights Act, is to, you know, have a legal mechanism to bring a challenge to voter intimidation that we see at the polls and across the state.
Okay, so
Call Mikey Sherrill.
I want to thank you both, DaWuan, Norwood, Tony Wall, for coming out here, spending so much time. If you have any final thoughts that we could, you know, move forward with, hopeful thoughts, you know, please let us know. And also thank you everyone for coming out here. We have to do more of these and get the word out.